We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty.
Derek Chauvin was found guilty on all 3 charges in the murder trial of George Floyd. But even before the verdict was read, the judge hinted that Chauvin would have a great case for appeal, thanks to Congresswoman Maxine Waters and her calls for protesters to become more confrontational if a guilty verdict weren't returned. Here is what Maxine Waters said at the protests this week.
But I know that the right wing, the racists, are opposed to it, and I don't know what's going to happen to it. But I know this: we've got to stay in the street, and we've got to demand justice. We're looking for a guilty verdict. We're looking for a guilty verdict, and we're looking to see if all of the talk that took place and has been taking place after they saw what happened to George Floyd, if nothing does not happen, then we know that we've got to not only stay in the street, but we've got to fight for justice. And we've got to get more active. We've got to get more confrontational. We've got to make sure that they know that we mean business.
And here's what the judge had to say about that.
Information relevant to this case, it is impossible to stay away from it unless you literally shut off your phone, or you shut off your TV, you shut off your computer, and no such instructions have been given during the course of this trial.
Well, to be fair, the last few times I've advised them, I told them don't watch the news.
And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned.
Here with me now to discuss, legal expert Kelly Hyman. Thank you so much for being with us.
Thanks for having me. It's nice to see you.
Nice to see you, Kelly. Kelly, what are your first thoughts on the decision?
I think the jury listened to the evidence, and based on the evidence presented, that they came back and had a guilty verdict. I believe in democracy, I believe in our justice system, and I believe that justice prevailed. And my thoughts and prayers go out to the Floyd family who lost a loved one, because you can't ultimately bring someone back.
And Kelly, do you believe, in light of that decision, that there will be riots in the street anyway?
I hope not. I'm a strong advocate for peaceful protest, but I believe that justice has been served, and so I'm optimistic based on what I've heard, that nothing will happen like that.
And Chauvin was found guilty, as you know, on 3 counts: second-degree unintentional murder, third-degree murder, second-degree manslaughter. This could result in decades in prison. Can you tell us what that means for lay people who are not attorneys, just on its face as far as what we know so far?
Right. From my understanding, we're looking at, as you said, decades in prison, but I do believe that there will be some kind of appeal process based on certain kind of situations that happened during the trial, whether it's, where the defendants asked that the jurors initially be sequestered, also asked for a mistrial as well, but he could potentially have 40 years in jail.
And in light of the comments by Maxine Waters, some say that she could be the reason that this verdict could ultimately be overturned. In fact, I think that that's sort of a summation of what the judge indicated. What are your thoughts on that?
Well, the judge has stated that he asked the people not to listen to the news, basically giving them an instruction: do not listen to the news, do not watch the news. And then when the judge sequestered them, My understanding is that they did not have phones and they did not have access to the news, so that they didn't know that this was actually going on. But ultimately, if this case is appealed, which I think that it will be, ultimately the appeals court will look at that type of evidence and make a determination on whether or not there should have been a mistrial in the case.
So my understanding, I think maybe there's some debate as to whether or not the jury was ultimately sequestered, at least in the traditional sense. Can you go through what the term sequestered means officially? I think it's tough these days because media comes at us in so many different ways. But the traditional definition, I guess, of sequester, and because if you weren't completely cloistered, I mean, kept from basically all means of news, you were hearing about this trial, weren't you?
Well, and the trial itself, that's potentially, but the judge basically gave them instruction, the fact that they shouldn't listen to the news. Now, the sequester idea, the initial idea is that you're not going home, that you're staying in a hotel, that you're totally isolated 24/7. So you go to the courtroom, you take your lunch breaks, you go back to the courtroom, and then you go into your hotel each day. Now, when the jury started deliberating, that's when the judge sequestered, basically said the people need to stay out at a hotel until they make a determination of whether the defendant was guilty or innocent.
And so at that point, if before that they had some information, and then at that point they stopped paying attention to it, which we can't, I guess, particularly know, there are no checks or anything to see if they did or did not, for example, watch their televisions in their hotel rooms. And does this mean they did or did not have their phones, if you know?
My understanding is once they were sequestered, they did not have their phones. I don't know if their hotel rooms had TVs or not. Maybe there was no TVs in the hotel rooms. I don't know. But the judge, you follow what the judge says. The judge says, do not listen to the media. Do not, do this. So it's kind of like a checks and balance. But if someone ultimately did look at it and use that information, then that could definitely be an issue if there is appeal.
All right, and Kelly, there's an accusation of witness intimidation here. There was a severed pig's head left outside the former home of a Chauvin defense witness who said that George Floyd's death was accidental. This is scary no matter which side of this you fall on. It's un-American to intimidate a witness. Our judicial system doesn't really work if witnesses aren't protected. What role could this play, if any, in an appeal?
Absolutely, that could play a role in the appeal, that someone was, concerned about that. But also, there's also whoever allegedly did that, then they can have ramifications themselves for jury tampering, if that's the case, and brought charges against them as well. And then that could potentially happen as well. But I think if that's an issue, then the appeals court would look at that and make a determination based on that, if that was a factor to sway someone, a juror, to make a determination of guilty or innocent.
Okay, and also, can you tell us a little bit about what kind of timeline we're looking at in terms of an appeal?
Absolutely. So basically, the defendant will discuss this matter with his attorney, and so they have an opportunity to file appeal, right away, and they might do that. And then also the judge has the sentencing guidelines as well. It might do the sentencing, but we also, probably like in a month or so, I would have to say that I'm assuming that there's definitely going to be an appeal, especially since the defendant asked for a mistrial in the case. And initially, the defendants asked that this case be transferred, and the judge denied that. Also, the defendants asked that initially all the jurors be sequestered. So I could see in the next 30 days that there's definitely going to be appeal in this matter.
And are jurors allowed to consider effects on the community? For example, potential riots, like if a juror thinks that a riot will destroy their city. Are they allowed to consider that or not?
They want to base it on the evidence presented. The prosecution has the burden of the case, and so they must prove the elements of each crime. And based on the evidence that they see, they just may look at that. They may not look at outside factors or any other thing like that. That's That's why the judge gives instructions, curing instructions, as they say, to inform the jurors that based on the evidence that they must follow the law, which I believe that the jurors did in this case.
And do you think that police procedure and protocol will be reframed based upon what happened in this trial? Because to my knowledge, this is the first example of a police officer actually being convicted in one of these cases. There have been civil suits that have been won against basically, as you and I discussed on this show the other day, against taxpayers, against cities for wrongdoing in some of these cases where it is believed that police used excessive force that resulted in the death of people. But this is the first case where I believe a police officer has actually, in a criminal case, been convicted, to my knowledge. Do you believe this will result in changes in protocol in policing?
I do believe that it will. I'm hopeful and optimistic that there'll be some type of police reform, and I think that definitely that's something that's important to discuss. Absolutely.
And in your opinion, do you have any predictions in terms of what that might amount to, what policing will look like going forward, so that we don't see cases like this again?
I hope we don't see cases like this again. I think it's going to be, training is going to definitely be key. I think that's a strong issue of training the police officers. And so there'll be certain protocols and procedure in place, but definitely I think training is key, and that's the first step.
And do you think that things like being able to apply pressure on the neck will perhaps be limited to a certain time period? Because we all know about the infamous 9 minutes in this particular case, which a lot of people said, yes, you can put pressure on the neck, but it was the excessiveness, it was the reasonability that came into question as far as total layman's terms here. Sorry about that, not an attorney, but that seems to be like what came into play here. Do you think it will be about time limits and accessibility and excessiveness and reasonability that will be put into play in future protocol for police procedure here?
No, absolutely. I think so. And the training on that and what kind of situation that they're in, whether there's immediate, injury or harm or something like that, or if someone's handcuffed and, can't move. Absolutely. But there definitely needs to be some kind of change and reform.
Very informative. Kelly Hyman, thank you so much for being with us tonight.
Nice to see you. Be safe, stay healthy. God bless.